The webinar will begin in 1 minute. Welcome, everyone. We are pleased that you have joined us for today's webinar titled Trustee's Obligation to ILIT Beneficiaries. The webinar will last approximately 20 minutes, and at the end, you will be given an opportunity to receive supporting materials by email free of charge to you. You will also be told how you may email questions related to today's content to the presenter. Today's presenter will be Linus Sugis. Linus is the president of Advanced Underwriting Consultants. He and his team answer tax and technical questions posed by producers every day. Linus also spent 14 years working in the home office of a life insurance company in various roles. He also started, ran, and sold an estate planning law practice in the Nashville area. Linus will draw on his legal and life insurance experience during today's webinar, and here he is.
Thank you very much, Amber. Welcome, everyone. I hope everyone had a great 4th of July. I'm glad that you've joined us. For those of you who are live, back to work. For those of you listening on the recording on YouTube, glad that you're listening. We're going to talk today about the trustee's obligation to irrevocable life insurance trust beneficiaries. It's a topic we at Advanced Underwriting Consultants get asked about a whole lot. But before we get into the meat of that topic, let me remind you that we have these webinars every month. They are held on the first Wednesday of every month. And in August, we're going to be talking about stretch. There's a lot of rules about stretch that have changed as a result of the first and second versions of the Secure Act. And we're going to get into that on the 2nd of August at 11 a.m. Central. So feel welcome to plan to attend that. If you know of a life insurance or financial professional who could use hearing about the updated stretch rules, feel welcome to invite them to join us in August as well. Again, before we get started today, let's decide what it is that we will talk about in September. Your choices are late premium dooms buy-sell funding, Stoli gets spicy, or using UTMA. We're going to take a poll and decide what it is that you want to hear about then. I will go ahead and launch the poll. And the poll is now open, and I would invite you to vote for your topic. I'll give you about 30 seconds, and then we'll move on. I see everyone's voted. I am going to go ahead and close the poll and announce that in September we will discuss using UTMA, using UTMA. Thank you for voting, and I'll look forward to that topic in September. So let's go ahead and get started, and let's talk about the trustee's obligation to irrevocable life insurance trust beneficiaries. We're going to use the acronym ILIT for that. But before we get into much depth about what it is that we're going to talk about, let's talk about the role of a trustee of an irrevocable trust. And I searched online and found this pretty good definition from Wikipedia. Trustee is a person or firm that holds and administers property or assets for the benefit of a third party. And to me, it's important for those of us who are on this call to understand that the trustee owes an obligation to the beneficiaries of the trust, and that an ILIT is no different. And a lot of times, Jennifer and I will get calls from life insurance professionals or financial professionals that'll start with, well, my client is the trustee of the trust, and the client wants to do this. And usually they get a mini lecture from Jennifer or myself that goes something like, look, you got to look at the words of the trust to make sure that the trustee has the authority to do what it is that you're suggesting. It's not just the trustee who can do things willy-nilly. The trustee is obligated to follow the rules that are written inside of the trust document. And so in a lot of cases, we'll send the financial professional or the life insurance professional back to get a copy of the trust, or have the client who's acting as trustee get an opinion from the client's own attorney to make sure that they can do what it is that they're interested in doing. And that's really what this case is all about. With that backdrop, there's nothing too complicated about the case that we're going to discuss. We are going to talk about Volk versus Chapman, which is an Idaho case. We'll talk about certain lessons that can be taken from that case, and we'll also talk a little bit about some of the best practices that life insurance agents and financial professionals should take into account when they're dealing with trusts. So let's go ahead and talk about the case. As I mentioned, this is Volk versus Chapman. This is an Idaho case. We're going to talk about the trial court and the appellate court case. And the trial court and the appellate court both decided the same thing. The appellate court affirmed the decision of the trial court. The background of the case is this. We've got Bill and Margaret Chapman, who established an irrevocable life insurance trust in 1993. For those of you who are on this call who were in the life insurance business 30 years ago, you know that the federal estate tax exemption back then was $600,000, and the top estate tax rate was 55%. Now, the Chapmans, Bill and Margaret, named their 7 children as beneficiaries of the trust. And 3 of those kids were also named as trustees. The irrevocable trust owned a Phoenix home life policy, insuring Bill's life alone for roughly $2.5 million. And in 2004, the trustee of the trust decided to replace the Phoenix policy with a Jackson National policy as part of a 1035 exchange. As part of the 1035 exchange, the Jackson policy had a jumped up death benefit of $7 million. And the Chapman's son, Wade, was acting as trustee at that time. The policy listed the trust as its owner, which makes sense. In order to do a valid 1035 exchange, ownership both before and after the exchange needs to be the same. However, for whatever reason, it's not clear from the facts, the trustee, the Chapman's son, Wade, was listed as the policy's sole beneficiary. So what happened? Margaret and Bill both passed away in 2018. Wade, believing he was acting as trustee of the trust, asked Jackson National for the death benefit in November, shortly after his father's passing. Wade did not know he was the sole beneficiary of the policy until he asked for the death benefit, and he was told of this by a representative of Jackson National. And so Jackson National paid $7 million of death benefit to Wade, and he kept it. He kept it personally. He did not put the money into the trust, which of course ticked off his siblings. And so that's what led to the court case. So the court was asked to decide what needed to happen with regard to the death benefit. And so Wade made the argument that because he was the trustee of the trust, his parents intended for him to be able to keep all of the life insurance policy's death benefits because he was one of the beneficiaries of the trust. And the trial court and the Supreme Court both ruled there wasn't any evidence to support that idea. The trust named all of the kids of the elder Chapmans as beneficiaries. And so there was a clear implication that all of them would share in any death benefit that would be owned by the trust. The court went on to say that Wade really needed to seek court permission before he was going to keep all of the death benefit for himself. He didn't do that before he kept all of the death benefit, and so the court decided that he kept all of the death benefit unfairly. And one of the key elements in the court reaching its decision is that, you know, this was a 1035 exchange. The trust was the owner and beneficiary of the policy before the exchange, and the new policy, the trust was the beneficiary. I mean, the trust was the owner. And it seems clear that in order to make things consistent, the trust should have been the beneficiary rather than Wade by himself. And this was also kind of confirmed by the fact that Wade was surprised that he was named the sole beneficiary of this particular policy. And therefore, both the trial court and the Supreme Court ordered Wade to place the $7 million into the trust and administer the $7 million of trust money in a manner consistent with the terms of the irrevocable life insurance trust. Now, as I said, there's nothing about this that's really all that surprising. One of the lessons is that just because a person is the trustee of the trust doesn't mean they have the unlimited authority to act. That's an important idea that we talked about at the beginning of our session today, and it bears reinforcing. The trustee is bound by the words in the trust, and they have an obligation, a fiduciary obligation, to treat the other beneficiaries of the trust, even if they're one of the beneficiaries, they've got an obligation to treat the other beneficiaries of the trusts fairly. If the trust gives a trustee the power to make distributions to the trustee himself as a beneficiary, it is not the same as giving the trustee unlimited control over the trust's assets, which this case makes clear. Even though the trustee here, Wade, had the ability to make distributions to himself, he didn't have the authority to keep all $7 million of death benefit for himself. And courts, if they're called on to intervene in these kinds of things, are not kind to trustees whom they believe are abusing their powers under a trust. And the courts have a lot of discretion to fix perceived wrongs, which is what the trust or what the court did here. And it seems like it was the right decision based on the intention of the elder Chapmans. So what are the best practices? From my perspective, a couple of best practices to take away. First of all, when a trust is the owner of a life insurance policy, the trust should also be the beneficiary of the policy, unless the life insurance professional or client or both get different direction from the client's attorney, and that direction is convincing. And then the second takeaway is an idea that we've hit a few times already, and that is that, you know, if you're helping the trustee of a trust do something, right, you're helping the trustee of a trust purchase a financial product, be sure that the trust gives the trustee the power to act. At the end of the day, you don't want to help a trustee do something that's going to lead to litigation later on. And so part one of that is making sure that the trust itself gives the trustee the power to act. What are the takeaways from the case? Well, first, in the court case, the trustee found out the hard way that ignoring the rights of the other trust beneficiaries created some serious problems for the trustees. The case underscores how careful life insurance professionals need to be when they're dealing with trust-financed financial products. Other financial professionals also need to be careful when we're dealing with a trust. We need to understand what it is the trust says and what it is that the trustee is trying to do. And then also the case gives one more lesson, and that is it doesn't really say anything about how the beneficiary was screwed up it feels like it was a screw up, how the beneficiary was screwed up during the 1035 exchange process. It was clear the old policy was trustee owner, trust beneficiary. The new case should have been trustee owner, trust beneficiary, but instead was trust owner and trustee as the beneficiary rather than trust as beneficiary. That was a problem that led to the court case. And if agents are involved with doing that and making that kind of mistake, they're probably going to be open up to liability. So if you're involved in it, make sure that you're helpful and that you double check that everything is done in the right way. I'd like to thank all of you for joining us again today, and I will turn the program back over to Amber to wrap this up. Amber?
Thank you for joining us today. As a reminder, if you would like to receive supporting materials, feel welcome to email us at asktheexpert@advancedunderwriting.com. You may also email questions related to today's webinar. Feel welcome to join us for the next webinar on the first Wednesday of next month, August 2nd, at this same time. Next month's webinar will be titled Truthing the Stretch. You can also find an archive of past webinars on our YouTube channel, Advanced Underwriting Consultants. Please subscribe to our channel. It helps us to keep making free webinar content. Today's presentation will be posted on our YouTube channel by the end of this week. Finally, for more information about the services that Advanced Underwriting Consultants offer, including phone consultation and newsletter licensing, feel welcome to contact us at 615-224-1291. That's 615-224-1291. Thanks again and best wishes for continued success.